Hey everyone, it's the Our Shawn. Welcome to another edition of the McBride Attorney Law Show. Joining me today is Adam Hillier. He is a bankruptcy attorney. We are both University of Maryland grads. We've known each other for a while. We've worked on a couple of issues for clients together, and he's one of my go-to guys for bankruptcy issues and in Delaware. And he knows what's going down. So we're going to take some time today for you, or maybe somebody you know. I don't know how you got here. Maybe you're just a business owner just checking it out. Maybe you have friends. But if you know somebody who may be in a situation where you start to see some turbulence in their business, some problems, Adam's going to dig into what do you start doing? What are the options? So we really want to just get it out there on the table so everybody knows, we understand where we might want to go, what we might want to do. For those of you who haven't tuned in before or don't tune in often, I'm the Our Shawn. I'm a corporate lawyer. I'm a business guy. Help people with ownership and control. So that's mergers, it's capital raise, it's partnership agreements, contract negotiations. That's where I spend my time. And I spend a lot of time looking at the future of business, which is why I have this YouTube channel, which is about law. And I also have my Future Done Right channel, which is about the future of business. So check that out as well. But this show is about helping business owners understand legal issues connected to their business. That's why Adam has agreed to help us. Want to let you know, just drop your comments wherever you're watching. You might be at Our Shawn McBride Fans on his Facebook. You might be on the McBride Attorneys Law Show YouTube channel. You might be checking out a LinkedIn feed. Wherever you're at, drop comments. We want to hear from you. What are you learning from us? Also, what issues do you have? Because Adam's agreed to come back so we can tune in the content to you to make sure we get you what you need. Quick reminder from the lawyers. We don't do investment advice and we don't do legal advice on the show. Everything here is just for your general education, give you some ideas. If you have a specific situation you need advice, consult your attorney, get the advice you need tailored to your situation. This is just to give you some ideas, give you some talking points, get you pointed in the right direction, but go to your professional advisors. With that, Adam, welcome to the show. Thanks for joining me today.
Thanks, Shawn. Great to be here.
So, I think this happens with a lot of business owners. I don't know how many really successful people I've met who have had bankruptcy or financial challenges in one of their preceding businesses. Then they kind of figured it out and things went smoother. So the question is, if one of the people listening to the show, somebody that just Googled this on YouTube, or maybe somebody has a friend that might be having some business difficulties, what do you start to look at? What are the warning signs and what do you start to do if you start having some cash flow issues or other problems in your business?
Well, one of the biggest problems that I run into in the roughly 20 years or so that I've been doing this is that people start looking for help too late. And it might be that they haven't seen the signs that something's coming, but more frequently it's that they have seen the signs, but they put off the decision to do something about it until it's too late. One of the big problems that most of the people who come into my office or give me a call run into is that by the time they pick up the phone and call their local bankruptcy lawyer, they're out of cash. And, obviously you're insolvent, and so being out of cash is a big thing about that. But on the other hand, bankruptcy lawyers need to get paid too. And if you walk into a bankruptcy lawyer's office or call them up and say, I'm ready to do a bankruptcy case, but you don't have any cash to pay them, they're going to tell you, sorry, there's nothing we can do. Bankruptcy lawyers don't work on credit. So you have to be able to put up enough cash to get your company at least into a proceeding, and possibly, depending on who your lawyer is, through the proceeding.
Yeah. So you gotta kind of set some number where you have enough money to possibly go through a proceeding, and that really is your, pick up the phone and call point rather than zero in the bank account.
Well, that's true. And one of the other problems is, unlike very large companies where there's typically an accounting department and a controller and sometimes a CFO or a treasurer who is trained to look out for these things. In smaller businesses, a lot of times the people who are keeping track of the money are also the people who do the operations. So, for example, if you have a restaurant, the person who's watching over the money is the restaurant owner. And a lot of times you may be a really good cook, but you don't really know how to look out for the signs that your business may be teetering. So lacking cash is definitely a good sign that you may be running into trouble going forward, but it's not the only sign. You have to be able to recognize the profit and loss of your business. You have to be able to recognize the direction or trajectory of the economics of your business. It has to be your business and also the industry, because if you can tell that a year from now, your business is going to be substantially different than it is right now, you're better off planning for that now than you are in a year.
Yes. Well, all planning is better if you can do it long range. Obviously, I tell people that with general business planning, not planning for bankruptcy, but you got to foresee what's coming because that allows you options. So what are the options if you're in a business and you start seeing these warning signs? You don't like the way your cash flow is going. What do you recommend people do?
Well, of course, it depends on the situation, as always. The most flexible option for businesses, even small businesses in a lot of cases, is a Chapter 11 case.
Yep.
Chapter 11 allows you to restructure how your debts are paid, treat all of your creditors or most of your creditors in the same way, and to be able to set up how they are paid in a way that you know that you can manage.
Right.
The downfall, of course, or the drawback to Chapter 11 is, of course, that it costs the money itself. You have to pay your lawyers to do it. You have to pay sometimes an accountant. There's actually a bankruptcy tax that you have to pay to the U.S. Trustee's Office. There's a whopping filing fee of well over $1,000 that you have to pay just to get into Chapter 11 for the court. So you have to be sensitive to the fact that you may get a lot of flexibility, but you may also not be able to afford it, and there may be other options that you should look at as well.
Yeah, so let's dive into that as well. Let's unpack a little bit. I mean, what else can you do? I mean, if you're getting into that situation where this becomes prohibitive, right? We talked about planning ahead, but let's say you're a little past the line or you're just small. Well, what are your options? What should people be thinking about?
Well, frequently, if you can, the most effective remedy or the most effective way of resolving the issues with your creditors is to reach out to them and try to work it out with them. If your problem is one creditor or one landlord or maybe two or three at the most, frequently if you contact them and let them know that you're having difficulty meeting your obligations to them, they will know that your other option is going to be an expensive and protracted bankruptcy proceeding. And frequently they will be willing to work with you. Banks frequently are willing to modify the loans that you have. Landlords may be sensitive to the fact that you can't necessarily pay all of the rent, but if you can pay some of the rent and you can do so timely and there's some transparency, the landlord will frequently make concessions for you, those types of things. There are other options that mostly involve liquidation. So if you realize that your business may be teetering not just from some temporary problem, but really it either isn't generating enough business or your creditors have just become too overwhelming, you may have options to liquidate the company as well that may be less expensive and frankly require less work on your part.
Yeah, so depending on the practicality of it, it may be easier just to go through a wind up and basically then deal with the creditors that way rather than try to go through the formal blessing of the bankruptcy court.
That's true, and you have to be careful about the use of the word wind up because it has different meanings in different states.
Sure.
In some states, for example, you are not allowed to do a wind up or a dissolution unless you're solvent. You have to be able to pay all your creditors in full, or at least have a plan to do that. So there may be insolvency equivalents to that, and that's something you need to raise with your lawyer.
Yeah, and you got to figure out where I guess state of incorporation is one of the driving issues there for that.
Very frequently, yes. And for bankruptcy purposes, you can actually often file where your headquarters is located or where you do substantial business. But a lot of the times, it's where the state of incorporation of your entity.
Yeah, and for some companies, that's different, right? Some companies it's the same. They file their documents in the state they do most of their operations in, but particularly I think in Delaware where you're at, you see a lot of companies that are filed as Delaware companies, but maybe operating somewhere else. Yeah,
and Shawn, don't forget too, one option may be to do nothing. And this may sound ridiculous, but if you've set up your entity correctly, you've consulted a lawyer about the responsibility of the company, the responsibility of you as owner of the company. If the company is going to be unable to make it, and the company's debts they belong to the company and are not debts of you, I've seen it before where the best option for the company's owner is simply to shutter the location, hand the keys to the landlord, tell the creditors there's just nothing left here for you and walk away from it. That isn't always a good option. In fact, that can come back and haunt you sometimes. And when you have aggressive creditors, then even if they don't have the ability to collect from you, they can still drive you absolutely nuts with collection proceedings. But in some instances, that does work, and you should talk to your lawyer about whether that option would work for you as well.
Yeah, and I want to add one more layer on it, which I've seen with one of my clients last year, which is, you also have to think about who your investors are, right? So it's not just your creditors, but we were in a situation where they were teetering in this space where the cash flow was tight, and they couldn't figure out what to do. But not only was bankruptcy, but they had other investors that were in the company. And so they had to think not only of what our creditors do if we go certain paths, but also what might my investors do.
Right. And you have to be careful, too, because you may have formed the business just to protect the assets and the operations that you had, whatever your business was doing. But as soon as you formed a business or an entity, you suddenly became this special thing called a fiduciary for that. And your duty as a fiduciary may be owed to the shareholders or the members of the LLC or whatever your equity holders are. And if the company becomes insolvent, you may actually have a duty to your creditors. And that duty may, again, drive you crazy or haunt you afterwards, depending on whether you made decisions that were in the best interest of the company. You should check with your lawyer to determine whether whatever you're proposing to do with the company would be consistent with your fiduciary duty. Because if you do something that harms whoever you owe that duty to, those people can come back after you. So, for example, let's take let's say you have a restaurant, and the restaurant is not going to be able to make it, and so it's not going to be able to make it. It has $10,000 of equipment, so you take that equipment and you give it to your new restaurant, and you start a new restaurant and you dump the old one. You've just harmed the creditors of the old restaurant and benefited to your own benefit, essentially. That can come back and haunt you under some cases, and your lawyer will be able to explain to you what the best things to do and what are not.
Yeah, we see that a lot with the equipment, customer list. We also see it with the name, right? So there's probably a lot of people want to move that name over to a new business, keep the name recognition. But then not deal with some of the debts and other issues. So you got to be very careful here. Want to underscore that fiduciary duty point. And this is very complicated. Lawyers will go back and forth because these fiduciary duties, investors, creditors, they can move around, right? I mean, there's Delaware case law out there and other that suggests at some point you may start owing the fiduciary duty to your creditors. So there's some magic time potentially where it shifts, right, Adam? I mean, it moves potentially from having a fiduciary duty to one group of people to having a fiduciary duty to a group of people or maybe a broader group of people. We just don't, there's some uncertainty here, which is why you need to get some good minds working with you.
Well, certainly. And, there was talk for a long time of what they call the zone of insolvency, where your duty started to shift. Probably a little outside of the scope of our conversation today, but the important thing to remember is just because your business now seems to be failing, you don't want to just create another business, move all the assets into the new business, and act like the creditors of the old business have been locked out. Somebody's going to get mad, and somebody's going to try to do something about it. And at that point, it makes you look like you did something wrong. Whereas you could have protected yourself simply by doing the right thing at the time, now you've created some liability for yourself and for the new business, and you haven't really helped anything. You've just sort of prolonged the problem.
Absolutely. And that was the point. Yeah, we don't want to get into a fiduciary duty analysis here. It's way beyond the scope, and lawyers can spend days talking about that. Right. The important thing is gets people advising you, because this can get very tricky very quick, and it's even hard for the lawyers to figure out where to pin the tail on the donkey.
Right. Now, bankruptcy law and state law of just about every state, as far as I know, have the right thing to do for you. If you believe that the business needs to be liquidated and you don't want to handle the liquidation, or you don't feel that you can handle it in a way that will get creditors paid, you can either file a Chapter 7 case under bankruptcy law, or most states have voluntary forms of insolvency cases like receiverships or what are called assignments for benefit of creditors, other types of proceedings that your lawyer should be able to explain to you as an option. These tend to be very inexpensive compared to restructuring types of bankruptcy, and they tend to take the work off of you once the case has begun. So basically, you begin the case, you provide some information to the court, to the trustee in the case, whoever that's going to be, and hopefully, if you've done it right, you can walk away and let the trustee, supervised by that court, make whatever liquidation is needed, and then you sort of walk away and start your life over again, which is usually at that point your goal.
Yeah, it sounds like a much simpler process than your typical bankruptcy filing.
Yeah, much easier. One thing to keep in mind too, a lot of people don't know when to pull the plug. Not just when it's time to call your bankruptcy lawyer, but actually when it's time to stop the hemorrhaging of your business, whatever it is. I've seen my own clients over the years. The individuals have put every dollar of their family fortune into the business to the point where they've been bled completely dry.
Right.
You don't want to use your retirement funds. You don't want to use the funds that may be available to you in the future when you need them to prop up a business that is likely to fail no matter what. There are kinds of assets in your personal bankruptcy, if you need it, that your creditors can't touch. And if you use that kind of money to prop up your business, then you really haven't helped anything and you've hurt yourself in the long run.
Yeah, exactly. So, again, that's going to be governed by state law. Adam makes a fantastic point, folks. Go back, and this is why you probably want to talk to a lawyer sooner than later. Just go in for a consult, spend a couple hours or whatever it takes to work through it, understand where it looks like, because your state law may protect cars, homes, furniture. Certain things are protected under various different state laws. So don't liquidate those things and pour the cash into your business, because then those assets are gone. You can't pull that money back.
Yeah, when you say that, Shawn, you're referring to the furniture and other items belonging to the individuals. The corporate assets, they aren't subject to those exemptions, and they can be used in liquidations. But in order to protect, a lot of times when you're putting your company into bankruptcy, you are worried about protecting the company, but ultimately you're worried about protecting yourself.
Right.
And so you have to understand what exposure you have at the same time that you are looking into what exposure the company has. Frequently, your bankruptcy lawyer will make you get a different lawyer for yourself. Because a lot of times, the two clients, you and your business, may technically be adverse to each other, at least the way the rules that apply to lawyers work. So, don't be surprised if the commercial bankruptcy lawyer says to you, I need you to get your own lawyer for this. A lot of times they'll work together. So don't be afraid about that. I know there's an expense. It often is worth it, especially if you've been advised to do that by your bankruptcy lawyer. I would recommend following that advice, whatever that is.
Right. I mean, it's just, the point is the planning. And yes, if I was a little slippery there, folks, I mean, what happens a lot of times, hopefully you have your entity set up correctly. That should be a firewall. The business debts are business debts, your personal debts are your personal debts. That's the way it should work. But a lot of times there's guarantees, there's other things flowing back. And of course, when people start getting in trouble, they start feeding personal cash into the business, liquidating personal assets. That's why you need to look at this, as Adam suggests, as a coordinated effort, right? You need to look at both sides of the ledger, how everything plays together, what your situation is. And it's somewhat complex, right, Adam? I mean, I think, we're trying to give you talking points and key issues, but it's just very individualized based on where you at and what your situation looks like.
That's exactly right. Yeah. Another thing to keep an eye on is when you realize the business is starting to go under or have trouble, later on, people are going to go back and look specifically at the transactions between the company and you. So if you start paying yourself for no reason, or for a larger salary than you would ordinarily have been taking, or reimbursing large expenses that don't look like business expenses, or paying your mother-in-law or your wife or your husband or your children's tuition. I've seen a whole lot of things like that where people came to realize the business is going to fail, so I might as well use the cash to benefit myself. It comes back and haunts you. And don't be afraid. We were talking before about consulting your lawyer, and that's really important. Make sure you tell your lawyer everything that's happened. Don't hide this from your lawyer, because what's going to happen is later on, when somebody else finds it, it's going to catch your lawyer flat-footed, and then your lawyer won't be able to get you out of it.
Right, and we've been there, and I'm remembering one of my cases. I was actually brought in by a personal injury firm because a company had transferred a bunch of assets to the key parties, and then didn't have money to pay a judgment. And we went backwards and we looked at it. It's a fancy term for it, is a fraudulent conveyance. Bankruptcy has kind of parallel concepts or ideas, but the idea is you can't just move stuff out of the business because you want to. There has to be a business reason for it. It has to be fair to the creditors and fair to your investors. So be very, very careful in that situation, as Adam puts it.
In fact, what ends up happening in those cases is if you have a quote-unquote creditor that happens to be a family member or a close friend, and you think, well, I'll just give the money to them, that's the person that gets sued, not you. And what you've done, you thought you were helping them out, but you've actually dragged them into a lawsuit. And so keep that in mind. Talk to your bankruptcy lawyer about it, and they will explain to you exactly what the potential exposure is and how you can use the money wisely in a way that will not harm you or the people close to you.
Yeah, folks, I think Adam's given us a great primer on what to look out for. The time has gone very quickly. We're going to have Adam back. We want to do a series here where we go through these issues, which is why we want your comments. So if you're seeing this, drop your comments below. But Adam, thank you for giving us such a great overview and at least getting people pointed to where to start. Why don't you tell folks how they can find you and your work, should they need you or should they just want to have a chat?
Oh, no problem. So the best way to reach me would be to go find my website, which is adamhillerlaw.com, or you can email me, which is ahiller@adamhillerlaw.com. Obviously, I can't give you legal advice by email, or by phone, at least initially. But if you have some issues you want to talk through, or if you need anything explained that we've talked about on this program, feel free to give me a call or pop me an email. I'm happy to help.
Yeah, and I'll put that general disclaimer. As we said, we're not doing legal advice, and I'll underscore what Adam said, which is your initial email to Adam, don't tell him your whole story and every problem you had. Reach out, set up a telephone conversation. He can work you through the process of whether it makes sense to be a client. He may need to refer you to somebody depending on your jurisdiction, whatever, but just start with a general let's have a chat, email or phone call. Take it from there, folks. So one step at a time. Adam, thanks again for adding so much value. Folks watching this, pat yourself on the back. I mean, this is a difficult issue, maybe helping you, maybe helping a friend, but taking the time to invest in yourself is always important. So I always like to thank my audience for doing that for themselves. I want to remind you, you can check us out more at McBrideAttorneys.com, the McBride Attorneys Law Show on YouTube. Make sure you subscribe, ring the bell so that you are getting our notifications. Get on our email list over at McBrideAttorneys.com so we can bring you more tips. And we're looking forward to seeing you again soon for another episode. Adam, thanks again for being here.
Thanks, Shawn. Great to be here.